Good afternoon, everybody. My name is Romy Jurado. I'm an attorney here at Jurado and Associates. We are a law firm in Miami, Florida. We practice many different areas of law, such as immigration, litigation, probate, estate planning, trademarks, copyrights, real estate closings all over the state of Florida, probates all over the state of Florida. And if there's something that we don't do, we could always work with an attorney that does and then refer to the right professional. I've been an attorney for over 10 years. I practice in the areas of business law, business immigration myself. And one of my favorite topics is anything that has to do protecting small businesses. I'm a small business myself, and intellectual property is one of the most important things. In fact, I think is one of your most valuable assets that as a business owner you have. And I see a lot of issues where people think that just because you created a company with a company name, that name is protected and nobody else could use it. That could not be farthest from the truth. So today's class, I want to focus on trademarks and intellectual property and anything that has to do with your small business. So if you have any questions regarding just general small business law that you want to discuss, by all means, feel free. I like to make my presentations short and to the point. I know we're all busy and that's great, especially what's going on around the world. So any questions that you have, please put them in the Q&A or put them in the chat. I will gladly answer them. And if for some reason I can't answer them at the moment, then please, by all means, feel free to email me or call me. I'm very accessible also through social media. You can do that as well. So I'm going to start sharing my screen with everybody with my presentation. And let me see if everybody can see it. Just 1 second. All right, so there you see us again. That's me. That's my firm. And again, we do is business law, real estate law, immigration, probate, estate planning, and litigation, which I don't see there, but it is something that we do. Thank you so much, by the way, for joining me here today. Okay, so Trademarks 101. What you need to know about trademark prosecution. It's called like that. Don't be scared. That's just a regular name. That's basically what it's called when you file a trademark. We're going to discuss today a little bit about types of marks, the benefits of trademark registration, selection of the marks, requirements for registration, dealing with the trademark examiners, and registration with U.S. Customs. So types of mark. What is a trademark? What can you trademark? You can trademark a word, a name, a phrase, a symbol, a design that identifies your business. So if you have a slogan, you can trademark that. Your business name, you can trademark that. You could, if there's a symbol that if I look at it, you want it to be associated with your business, you need to trademark that. Your logo can be just the words, or it can be a design. In order for it to be protected, you need to trademark that. So what is a trademark, or what can you trademark? Any word, any name, any phrase, symbols, or designs that you want people to associate with your goods and services and that you don't want others to use, okay? So it's used to identify distinguished goods from those manufactured or done by others, to indicate the source of goods, even if the source is unknown. So that is what you can trademark. I think I'll have a lot of realtors as part of my presentation today. I do have clients that want to trademark their name because they don't want any other realtor to use their name to promote their services. They want to trademark the name of their group. Now, I understand that you could operate under a brokerage. In order for you to, operate, you have to operate under a brokerage. But a lot of you guys have like a team name, right? So you can protect that as well. You can protect your team name. You can protect any slogan that you use, that you always say, that you want associated with your real estate services. You can trademark that as well. So anything, remember this, that you want to associate with your business that involves a word, a name, a phrase, symbol, or a design. Maybe your logo is super fabulous and you want to trademark that. You can do so as well. Just because you filed in the Florida Secretary of State or SunBiz for a company name, or because you filed a doing business as or DBA or fictitious name, that gives you no trademark rights. So somebody else can go and form a company under whatever name, maybe not the same one because it's already taken in the state of Florida, but they can form another company name, file a DBA, and do business under your same exact name. Filing for a company name gives you absolutely no protection. I want to just reinforce that because I've had many issues where people come to me and they tell me, Romy, we need to do something. This person is operating this exact same business of what I do under this name, and I want to stop them. And I'm like, okay, did you register a trademark? Yes, I did. I have my name registered. That's not a trademark, okay? Also, very important to understand, trademarks, you can register a trademark at the state level. So every state, including Florida, has its trademark office. You can register a trademark at the state level. I don't recommend that. I want to go for the federal trademark. So that way you're protected in all states. So if I register a trademark here I'm doing business here in Florida, and I've done, I'm being seen through the internet from all over the United States, and I register a trademark at the federal level, somebody in New York cannot operate the same business that I'm doing under that name. Somebody in anywhere cannot within the United States. How do we stop them? Well, first we find out about it. Second, we send them a cease and desist letter. And if they don't stop operating under that name, now we can sue them. And because we have a registered trademark, we can recover attorney's fees and costs. All right, so types of marks, continue. What is a service mark? So a service mark is the same thing as a trademark, okay, except that they identify distinguished services instead of products. For example, American Airlines, it's a service mark. McDonald's, it's a service mark. Why? They provide a service. If I were to trademark something for my law firm, it would be a service mark. So what protection is available? The rightful owner of a trademark or service mark, usually we all refer to them as trademarks anyway, can prohibit others from using the same mark or another mark which is so similar in sound, meaning, or appearance that it would be likely to lead to confusion among customers regarding the source of the products or services in connection with which the mark is used. In other words, if you have a trademark, let's say your trademark is American Airlines, and somebody else tries to use United States Airlines, they could probably stop them because it kind of has the same meaning, you see? And that is what trademark protection gives you. Not just your trademark itself, but it allows you to stop others people use that would create what they refer as confusion in the marketplace. We don't want, or not we, the United States Patent and Trademark Office, don't want people to be confused and tricked. So if you're giving a trademark, they're gonna protect nobody else using that name for those products and services, or using something similarly sounding or with similar meaning. I'll give you another example. I represent a lot of restaurant owners because I love to eat and I think it's great. When I file trademarks for restaurants, especially foreign restaurants, and their name is in a foreign language, I have to tell the United States Patent and Trademark Office, what does that name mean? Why? Because if somebody else has registered a trademark with that same meaning, even though it doesn't sound the same because one is in one language and the other one is in another language, they're still not going to let me register my mark, which is great for my clients, because I maybe do a product here in the United States, but I don't want somebody in China using that same name just with a different meaning, and that might help us protect there as well. Now, the trademark that you file at the United States level, it doesn't protect you anywhere around the world, but we could file trademarks there as well. The United States protection is really strong because once you do this, we're also part of the Madrid Protocol that allows us to register. I can register you in a bunch of other countries. So you're not limited to the United States. You have to be using the trademark in the United States in order to get a certification, but you don't need to have been using the trademark in order to start the process, okay? Because there's two ways to trademark. You can do and tell the United States Patent and Trademark Office, I'm using this trademark in commerce, give me the trademark. Or you can say, I intend to use this trademark in commerce. Okay, that's called intent to use. So a lot of my clients are filing intent to use applications because they're not using it right this second, but they want to start the process so that once they're doing it, the process is already advanced. How long does this process take? Honestly, 9 months, right? The registration or the protection is going to be backdated to the date that it was filed. But the process itself, it takes around 8 or 9 months. So that is why it's so important to get started as soon as possible, that you want to protect a name, a logo, a slogan, a design, so that we don't have to be pressed with time. Okay, so what can we trademark, right? Can we trademark pen for pen? No. We can trademark things that are distinctive, okay? So the trademark law only protects distinctive marks, because otherwise people couldn't use regular words, right? So if I were to trademark glasses for glasses, then nobody could use the word glass or glasses. Okay, they want it to be arbitrary, fanciful, and suggestive marks are deemed to be inherently distinctive. Descriptive marks is stuff that we cannot trademark. So what are descriptive marks? Geographic names, you're not going to be able to trademark geographic names. And surnames are not inherently distinctive and can only be protected if they can be shown to have attained distinctiveness through use referred to a secondary meaning. So you could include certain things as part of your trademark name. but we're gonna have to do something called disclaimer. So we're gonna have to disclaim part of that name because it's something that is so descriptive, okay? So I'm telling you, you cannot trademark pen for pen, but if I want to trademark Romy's pens, I could do that. I would just have to disclaim the pens part because I'm using it for pen. And so that's how you would do it. You could still file the trademark, you would just disclaim the part that's too descriptive. Generic terms are unprotectable and can never function as a trademark. Once a word becomes generic, it's lost for trademark purposes. So if everybody refers to something using a word, you cannot trademark that word for that something. All right, somebody's asking me about how much does it cost to go through the whole trademark process at the federal level through your firm, including all fees and charges roughly. Okay, so I'm gonna discuss my fees when you guys email me. I'll be gladly, and I'm very transparent. But I can tell you that the United States Patent and Trademark Office charges $350 to per class. So the services or products are divided per class, and you usually file on their particular class, and they charge $350 for that. Then we charge a flat fee in order to file the trademark. And if there is litigation, if there's an office action where we have to do a lot of arguments and a lot of things, then we might charge hourly for that. It depends. And again, I will discuss my fees when you guys reach out to me, because I don't think we're allowed to discuss them via video. So I need to be careful with that. All right, next. So types of marks, right? It has to be distinctive, right? So arbitrary, for example, use words that are in common use, but bear no relationship to the associated goods, like Apple for computers. So could you trademark Apple for apples? No. But you could trademark Apple for computers. You could trademark Apple for cell phones. You could trademark Apple for a bottle of water. You see, so you use something, it could be a common word, but you're not using it for the meaning of that common word. You're using it for something else. Suggestive. Suggest some quality or character of the associated goods, but not so explicitly that no imagination is needed to determine the nature of the goods. For example, copper tone for sunblock lotion. That is trademarkable. It was, as a matter of fact, because you're saying copper tone and you could kind of associate it, but you're not saying sunblock. So, suggested marks is something you could trademark. Fanciful is composed of coined words. For example, Xerox for photocopiers. So you can use these guidelines to come up with a trademark that is going to be trademarkable because it's not descriptive or generic. So if your mark that describe the qualities or ingredients or characteristics of the products or the services with which the marks is used. So beef and brew for restaurant, they're not going to allow you to trademark that. Generic, a common group or class such as beer, shoe, or automobile to which a particular product belongs to. A generic term can never be trademarked for the identified goods. For example, Apple for fruits, you're not going to be able to trademark that. So, benefits of trademark registration. First, to use. In the United States, the federal registration is not required to establish rights in a trademark. Rather, common law rights arise from actual use, that is correct, of a mark, whether or not it's subject to federal registration. Generally, the first to use the mark in commerce or file an intent to use application with the USPTO has the ultimate right to use and register the mark. Registration is not required, even if the senior user does not have a registration for its mark under Section 43 of the Trademark Act. The senior user generally may stop a junior user that has obtained a federal trademark registration. That is correct. So if you file a trademark and it's granted and somebody else can prove they used it before you, they can do that. They can fight you on it, sadly. Registration, however, is recommended because even though registration is not required for trademark protection, it is advisable for a company to obtain registration for trademarks because it gives you the right to recover attorney's fees and costs in the case of a violation. And that's very important. So if I were to be hired with my team to stop somebody's trademark use and the person has no trademark registered, I'm going to have to charge them hourly. If the person has a trademark registered, then I could probably do it on contingency because I know that they're going to be able to recover attorney's fees and costs. And trademark registration is not that expensive. It really isn't compared to the protection that it gives you and the ability to obtain your attorney's fees and costs in case of infringement. So registration is recommended. Registration confers important benefits to the trademark owner, possibility of treble damages for infringement. So not only are we going to recover, one damage, we're going to recover 3 times the damage, which is great, and attorney's fees and costs. Presumption that the registrant is owner of the mark. So there is a presumption once you obtain registration that you're an owner of the mark. And after 10 years, there is something that we can file so nobody else can fight you on. Geographic coverage for the entire United States, even if it's being used in the localized area. So you only sell real estate in Florida, that's okay. You're gonna be protected all over the United States. And what do you do with that? Well, I have clients that have licensed their trademarks to other companies in other states or in other areas where their market is not part of that. You're allowed to register your mark and you can get paid for that. It is something you can receive money for. Incontestability. After 5 years upon filing an affidavit, after 5 years of continuous use, we can obtain some incontestability. Also, because you have a trademark registration. So let's talk about selection of the marks and the symbol, the R symbol and the TM symbol. When can you use them? When can you not? So the R or register symbol is used by trademark owners to give notice that a particular mark is registered with the United States Patent and Trademark Office for a particular goods or services, may only be used after federal registration has been granted. Even if a trademark application is pending with the USPTO, the symbol may not be used until the mark becomes federally registered. So just because you hire me to register your trademark, you cannot start using the R on it. You have to wait till it's registered. Improper use of a federal registration symbol, if done with intent to deceive the purchasing public or others in the trade into believing that the mark is registered, is grounds for denying registration of an otherwise registrable mark. So be careful. The TM symbol. The TM symbol is used by trademark owners before they obtain federal registration for their trademark. The use of the TM symbol, while not required by trademark laws, can serve many useful purposes for a trademark owner. You're telling people I have common law rights, but it's not a registered trademark. Selection of the marks and infringement. Okay, so we have something called the DuPont factors. In the court, in this case, okay, in an application proceeding set forth 13 factors to be weighed in determining whether one mark is likely to be confused with another. So 1, they look at the similarity or dissimilarity of the marks in their entireties as to appearance, sound, connotation, and commercial impression. 2, the similarity or dissimilarity of the goods for which the marks are used. 3, the similarity of the channels of trade of the goods for which the mark are used. For example, I remember having a successful argument for a mark that they didn't want to issue, but we argued that our brand was being sold very high end and the channels of commerce were very different than the other brand that was being sold at Walmart, and we were able to get it. The sophistication of the purchasers, impulse buying versus careful, sophisticated purchasing. The fame of the senior mark, the number and nature of similar marks in use or similar goods. So there's many marks being used in similar goods. We can say this is not going to confuse the market. The market hasn't been confused because other similar marks have been registered. The nature and extent of the actual confusion, the length of time under which there has been concurrent use without evidence of actual confusion. So if we say, look, we've been selling under this mark for the past 10 years, no confusion yet, please give us the registered trademark. The variety of goods on which a mark is used, the market interface between the junior and senior users, the extent to which the applicant has the right to exclude others from use of its mark, the strength of the mark, the extent of potential confusion, any other established fact probative to the effect of use. So all of these things, the DuPont factors, is what we would use in case the United States Patent and Trademark Office sends us an office action telling us that, you know, for some reason or another, they don't want to register a trademark. Then we would come back, make these arguments to say, no, yes, you should. And then sometimes we're successful, sometimes we're not. So, you know, it just depends. All right, let's go to the next slide. I don't see any questions, but please, if you have any questions, put them there in the chat or in the Q&A. So there's something called clearance searches. You know, when we file your trademark, we'll file it, no problem. But if you want us to do a clearance search, if you want us to search to see if, you know, what we think and give you a legal opinion, that is something that we can do. It takes measures to avoid choosing an infringing mark and avoid future problems. We can do a trademark clearance search. We will search the federal applications or registration. It's good for eliminating marks and potential considerations because I have clients that tell me, Romy, I have these 3 marks that my marketing department has told me would be really good for my business. Which one do you think I should register? So I cannot tell you this from my head. I said, okay, let's do a clearance search and then I can issue you a legal opinion. We search both registered and unregistered uses. It's not perfect. the United States Patent and Trademark Office can still find something wrong with it, but it's better than nothing because it's going to give you a better idea. I've had done clearance searches where I clearly tell the client, listen, I don't think your mark is going to register, but you never know. And they said, no, I don't care. I still want to go through with it. No problem. Then when we get the office action, it's already expected and we're able to fight it. Sometimes yes, sometimes no. So it just depends. But I do advise to get clearance searches because it's going to give you a better idea whether your mark is registrable or not. So use mark, it's ultimately required for registration. I told you that we can file an intent to use application. Yes, you can. But you're not going to be given the certificate until you're actually using it in commerce. So assuming a mark is capable of registration, the mark ultimately must be used in commerce before the United States Patent and Trademark Office will issue the registration. Use in commerce is defined as all commerce which may be lawfully regulated by Congress. So if you sold from here to New York, that's using commerce. This typically includes commerce between states and commerce between the United States and a foreign country. So if you sold from Miami to Peru, that's being used in commerce. Sales of goods across state borders or into the United States from a foreign country will constitute use in commerce. There's also two registries. There is a principal registry and the supplemental registry. So there are two main paths to registration on the principal registry. Use-based applications, a person or company who already has used a mark in commerce may file an application based on use. Intent to use, as I explained to you, a person or company who has a bona fide intention to use the mark may file an application based upon this intention to use the mark. A registration will not be issued until the applicant has begun to use the mark. Then there is an initial examination of both the use-based applications and the intent to use-based applications, and the examiner assigned to the application reviews it to make sure that it complies with statutory requirements and to determine if there are any grounds for rejecting the mark. Effect of rejection. If the United States Patent and Trademark Office issues an office action, the applicant may respond, usually through an attorney, with arguments why the mark is registrable. A response is due 6 months from the date of the office action. So important to file this response on time. If the response is unsuccessful, the rejection is generally deemed to be final in a second office action. It is possible to file a request for reconsideration within 6 months of appeal. It is possible, we can do it if you want. Effect of acceptance, okay? So this is when they accept you. Publication in the official Gazette of Trademarks. So there is a period, once your mark is accepted, it's published in the United States Patent and Trademark Office newspaper, which is called the Official Gazette of Trademarks. They have a 30-day opposition period for interested parties, subject to extension up to 120 days from the publication date. So it's open for the public and anybody can file an opposition and say why your mark shouldn't be registered. Somebody's asking me if this class will be recorded. Yes, it will be. Hopefully the video comes out good. I can upload it to my YouTube and I will share with everybody. If opposed, okay, opposition proceeding in the Trademark Trial and Appeal Board will determine applicant's right to register the mark. So somebody opposes your trademark registration. Now we have to go to the Trademark Trial and Appeal Board to see who wins. If nobody opposes your registration, then it goes to the publication stage, right? So for those people, will get a registration certificate if it's use-based application, and the intent to use applications, if they file an amendment saying, yes, I'm already using it, they will also get a certificate. Notice of allowance for intent to use application. So if you're still not using it, because you could extend the period of not use, then you're going to get a notice of allowance that's going to say, look, your trademark is not being opposed. The United States Patent and Trademark Office says that you can be registered. So just show us you're using it in commerce and we will give you a registration. Okay. People are asking me if marks often get opposed after publication. Does it happen a lot? No, it does not. Thankfully, it does not. Okay. I mean, I have not had one, and I've been doing this for over 10 years. Thank God. So far, nothing. Requirements for registration, renewal. Section 9, renewal application with declaration of continued use must be filed every 10 years after the registration date, okay? Filing fee per class, specimens of use must be submitted and we will be examined as before. Goods and services not in use must be dropped from the registration, 6 months grace period, additional fee paid per class. Section 8, also need to file a Section 8 declaration of continued use, filing fee per class. So this is what we do after you receive your registered trademark. The identification is unclear and needs to be clarified. So if you receive something that says that, then try calling the examiner, or your attorney should help you figure this out. And then we will look at it and see, or you shouldn't have this issued if we filed it to begin with, because it would tell us how to better clarify your goods and services. Sometimes a client tells me, Romy, look, I plan to sell, let's say, property under this trademark, but eventually I would like to do shirts, I would like to do a YouTube channel, I want to be an Instagram sensation, I want to start my newsletter, and I want to protect my trademark for all of that too. So in all those things, those are different classes. Some you're already doing, so we're going to say you're using that mark in commerce for the real estate services, but you haven't done your YouTube channel yet that you want to protect, so that's going to be intent to use. You're not selling t-shirts with your slogan yet, so that's also going to be intent to use, and things like that. So what we do is we like the client to tell us everything that they're doing and what they plan to be doing, so that we can see, okay, this is what we're using right now, this is what we plan to do, let's file an intent to use application. Okay, dealing with trademark examiners. They're actually very nice, but think about it this way. Their sole job is to be the gatekeepers to the trademark registration. So they do their job and they do it really well, and they're working from home. So they have all the time in the world to oppose your trademark. That is why it's so important to file a trademark with an attorney, to do the previous research, to have an attorney that can fight them off if they give you a notice of action, so that you can, an office action, so that you can be protected. So likelihood of confusion, that's the main office action that we get. And what we do is we try to narrow the identifications of goods and services to distinguish it from other marks. We try to find the different components, sounds, or meanings. We try to argue that there is different channels of trade. We try to say that the customers are sophisticated, so they're not going to get confused. So all these things we do at the beginning to try to get the registered trademark. So let's say you got your registered trademark. We're all happy. Yay, you got your trademark. Now you're going to start selling your goods, or maybe you already started selling your goods. It's so important that you register with customs, okay? Especially if you're bringing your goods from abroad, or if you just register with customs with your trademark. Why? Because you fought so hard to get your trademark, you're doing all your work here in the United States, and now somebody's importing from another country using your trademark, and there's nothing you can do about it because you won't know until the stuff is here. And how do you know what is the stuff that you did and what is the stuff that they did with fake logos and names from you? It's very difficult to tell. So what you do is you register with customs. So import of goods marked with infringing trademarks can be barred by U.S. Customs and Border Protection. Under the Lanham Act, no article of imported merchandise should be admitted to entry at any custom house if it copies or simulates trademarks registered in the U.S., copies or simulates the name of any domestic manufacturing or foreign manufacturer that treaty, convention, or law affords similar privileges to citizens of the U.S., bears the name or mark calculated to induce the public to believe that the article is manufactured by the U.S. or that it is manufactured in any foreign country other than the country in which, in fact, was manufactured. So they can help you stop it. How do you do it? You can file the form right there in the link. It's a form, it's a letter, or filed online through that link. And then you include the name, address, and citizenship of the trademark owner, the name and address of foreign persons or business authorized or licensed to use the trademark, the copy of the U.S. registration. This is only available if you have a registered trademark, and the filing fee of $350 for each class of goods or services in the trademark. If you include that, you can register with customs, and they will help you stop them. Now, in practice, additional efforts are often required beyond simply recording the mark to encourage local customs authorities to search for and seize the infringing merchandise. Trademark owners will typically see a higher success rate in seizures of infringing merchandise if they continuously provide customs with such helpful information as the identities of known foreign counterfeiters, their countries of origin, suspected importers, and the ports through which the merchandise is imported. So register with trademark. Register your trademark with the U.S. Customs Office, but also provide them information so that they can help you in basically coming after these people. If you know who are the known importers that are doing the bad things, if you know what countries they're coming from, if you know the companies that are counterfeiting this thing, then provide them that information so that they can properly assist you. Well, here is my contact information for those of you guys that don't have it. I want to take this time to answer any and all your questions regarding trademarks. It's a short presentation because it's really to the point. You have a name, you have a logo, you have a slogan. let's protect it. There's no way around it. If you don't protect it, somebody else will use it, and then you have absolutely no rights to it. So be careful with that. Let me see if I have any other questions. If not, I'll talk to you guys a little bit about non-competes. It's another thing. It's so important for businesses. Both for the business side, you should be getting non-competes for people that are doing services for you that you don't want them to compete with you. But also for the employee side, I do see a lot of employees signing non-compete agreements and basically signing their life away. Now they cannot even practice what they know how to do best. So when it comes to non-compete, please review them. Don't just sign them because your employer is asking you to sign it. Talk to your attorney and have them reviewed, because the saddest thing is when you sign a non-compete 4 years ago and then now you're leaving the company for X and Y reason and you cannot do what basically you know how to do. And so be careful with that. Don't just be signing stuff left and right. Fully analyze it, because if you sign it, you're going to be bound to it most of the time. So somebody's asking me, what about American Airlines? They're both service, American Airlines and Alcoholic Anonymous. Oh, AA, you mean? All right. So that's a great question. So just because you trademark under one product or service class doesn't mean you're protected for everything else. So American Airlines or AA, they probably have the trademark under the airline class. But if somebody else wants to start selling phones with AA under that class, they can register a trademark. If somebody wants to start, I don't know, Alcoholics Anonymous, an association, they can still do it with that trademark. Why? Because you protect per each service or product per class. So unless you're protecting in all classes, other people can still use the trademark. They just cannot use it for something associated with your business, with your product or service, assuming you protect it in that class. So that is important. Don't think that because you got a trademark in one class, nobody else can see it, can use it in any other class and to sell any other product and service. That is not correct. You protect per class depending on the product or service that you're selling. All right. Well, again, my name is Romy Jurado. I'm an attorney here in Miami. My law firm's name is called Jurado and Associates. We're here to serve you any which way we can in the different areas of business law, immigration, litigation, probate, estate planning, and of course, trademarks. If you have any questions, we gladly answer them. I will be sending you all a follow-up email with the link to this presentation tomorrow, including the presentation. And I hope everybody took a little bit from this. If you have any questions, by all means, feel free to reach out. And thank you so much for coming to my presentation today. Bye-bye.